May it please the court, my name is Tyler Cavanis, here representing the appellant, Robert Atkins, and with the court's permission, I'd like to reserve 5 minutes for rebuttal argument, please.
Certainly. 5 minutes.
All right, very well. Your Honors, over the last few months, I've gained maybe last year or so, I've gained a new appreciation for brevity, and so I will, that's probably surprising words to perhaps all of this panel, but this is a case where I do think that some brevity on my part is appropriate. I think this issue was well briefed. I think the facts of this case are pretty straightforward, and so I do have some, certainly I want to have any discussion needed with the court, but also my primary intent today would be just to supplement some arguments that were raised in the briefing with information I believe will be helpful. So this is a case where Mr. Atkins went to trial here in Knox County, was ultimately convicted of the delivery of a controlled substance, or two controlled substances, Schedule 1 acetylfentanyl and Schedule 2 fentanyl. However, it was a mixture. We're talking about just one, ultimately one substance that was a mixture of these two drugs. The amount of the drugs that was recovered was notable in the sense that it was a very, very small substance ultimately, or quantity ultimately recovered. 0.03 grams is what was ultimately the basis of this conviction. I think that this case is unusual in some other ways, and that, at least in my experience, the charges of delivery alone without some kind of accompanying possession with intent charge, that's not been my experience in how these cases are often charged. And so this issue of simply an interpretation of what do the elements of felony delivery of a controlled substance entail, what is the interpretation of that, and the interplay between misdemeanor casual exchange. This case is sort of framed in an interesting and perhaps, at least in my experience, unusual way for the court. And so the first issue I'd like to talk about is the sufficiency of the evidence argument. In the briefing, I had these two subparts, the first subsection being that this case presents an opportunity and that this court should judicially interpret the statutory definition of delivery to clarify the interplay between felony delivery and the elements of misdemeanor casual exchange. And I proposed a definition to the court that I believe is appropriate in the sufficiency analysis. And ultimately the basis of that is because as these two offenses are currently defined, there is a statutory definition of delivery that essentially it is a transfer of drugs to someone else. I believe that it says the actual constructive or attempted transfer of a controlled substance. We don't have a statutory definition of casual or exchange, but there's a Tennessee Supreme Court case, State versus Helton. Casual means without design, and then exchange means to part with, give, or transfer a controlled substance in consideration of something received as an equivalent. And so we have this overlap of the words transfer, and really neither the case law or the legislative language gives some sort of differentiation between what this word transfer, what's the difference between transferring in the felony context and transferring in the misdemeanor context. Where we derive that differentiation is from Helton and the cases interpreting it, which define, essentially we're left with a position where we're defining felony delivery with the absence of these additional elements that would lead to the finding that there was a casual exchange. And so the state is in a situation where proving felony delivery actually requires less than to prove casual exchange, but by proving part of casual exchange, the state has satisfied all of the elements of a felony delivery of a controlled substance. And the crux of this argument is that really flips the criminal code on its head in the traditional way that these cases are presented to the jury, the traditional way that when we're talking about the same types of conduct, that the legislature criminalizes these and punishes these. And ultimately, I think that this case, my argument is that this case is an opportunity for the court, as it has done in other contexts, to not redefine the legislature, not to strike down this statute as unconstitutional or vague, but to say that the same way that the court has interpreted what casual means and what exchange means, this is an opportunity for the court to interpret design as it would be applied to the facts of this case. And ultimately, rather than looking at, is there or I think I said design, I meant delivery, rather than defining delivery by looking at the elements of casual exchange and saying, if we don't have these casual exchange elements, then we do have a felony delivery, I would propose that the court just needs to essentially move those elements over. That if the inverse is true, where if casual exchange means without design and to give or transfer, then a felony delivery should mean that the delivery occurred with some sort of design, with some sort of intention, and ultimately, instead of looking to another statute and the absence of those elements to define a felony drug delivery, this court should just through canons of judicial interpretation, bring those over to delivery. And in this case, and I also think that the state has made the argument that this would be some sort of violation of separation of powers. I would suggest that that course of action is exactly what the court did in Helton. Helton looked at there is a criminal violation called casual exchange. These two words are not defined, and the Tennessee Supreme Court interpreted those. And that was not rewriting the legislative intent. It was actually, or that was not rewriting the statute. It was looking to the legislative intent, harmonizing these statutes, and ultimately giving more meaning to the statutes based on what the legislature intended. And so this is not a separation of powers issue. This is simply as the court does with any sufficiency of the evidence argument, the court must first look at what is the law, what does the law mean, and how can we apply that to the facts of the case. I do want to point the court to a case that I did not include in my brief, but that was that I found in preparation for the oral argument. It's State versus Fleming. That's a Tennessee Supreme Court case from 2000. The citation is 19 Southwest 3rd, 195. And the reason I bring that case up is that's a case where the Tennessee Supreme Court was interpreting whether aggravated assault, or excuse me, whether deadly weapon as one of the elements of aggravated assault includes a person's hands and feet, and whether that could sustain an aggravated assault conviction. And applying the principles of statutory interpretation, both that this court has an overarching intention of harmonizing laws with each other, following the overall intent of the criminal code, but also avoiding absurd results. The court found that if hands and feet were intended to be a deadly weapon by the legislature, then that would essentially merge the two offenses of aggravated assault and misdemeanor assault. And I think that that's a helpful case, just in the sense that that's essentially what has happened here with delivery and casual exchange. I think that perhaps, well, certainly unintentionally, but I think that the Helton interpretation of what was before the court in Helton, and that was an old case, 1974, when the court was defining casual exchange, it didn't have the issue of what is a delivery. It didn't have that issue squarely presented before it, and by defining casual exchange in the way that it did, creating the overlap with the words transfer, I think that really this case presents an opportunity to harmonize Helton with what we currently have as the overall legislative intent of criminalizing the delivery of drugs as a felony, criminalizing a casual exchange of drugs as a misdemeanor, and creating consistency with the state being required to prove more things to prove a felony rather than fewer things as happened in this case. As to whether the court does or does not, I suppose, adopt this argument that I'm proposing, I think what courts have done consistently in the past, wrestling with this issue, is that, and I cited these cases in my brief, what the courts have done in the absence of sort of a more explicit definition of delivery is that the courts have looked to in deciding between a felony and a misdemeanor, well, were these elements of casual exchange present? And I would submit to the court that in this case, what the proof showed was that there was I believe the proof does show that there was a transfer of drugs. That's not contested. And in fact, it was Mr. Atkins' statement to investigators that he took the dope to the decedent in this case, who ultimately, this was charged as an overdose, second-degree murder case. Mr. Atkins was acquitted of that. The proof showed that what was in the decedent's system that led to her death was not ultimately found in this packet of drugs, that this 0.03 grams that Mr. Atkins was alleged to have delivered to her. And so there was an acquittal on that, and the only question then being left is this delivery. But what the proof showed is that Mr. Atkins and the decedent had a personal relationship. I think it is a fair characterization to say that they were friends, or that the proof showed that they were friends. He was borrowing her car at the time. He drove to see her that day in her car. There was proof from the state's witnesses that Mr. Atkins had some degree of a relationship with the decedent's family. The proof showed that they had talked on the phone that day, and it wasn't necessarily short conversations either. I believe that on that day of the offense, the date of the offense, that there was even a 12 or 15-minute phone call. And so the issue is that when we get past the elements of felony delivery, which are simply that a transfer occurred, all of these other indicators that would typically be present to show that there was some kind of preconceived plan, that there was some kind of consistent pattern here, those are absent in this case. There was no proof that there was any sort of money exchanged. There was no proof that there was anything given in consideration for these drugs. There was no proof that there was some sort of predetermined intention for Mr. Atkins to take the drugs to the decedent. What the proof showed was that they had talked earlier in the day multiple times, but not just that day. They had talked in the days leading up to the date of offense. He was borrowing her car. I would submit to the court that it's just as likely that he went to go see her that day for some other purpose, and that while there, a exchange of drugs occurred. The fact of the matter is that proof just simply wasn't in the record and wasn't developed in the course of the investigation. And so the jury was given instructions that ultimately told them that if a transfer was proven, then there's a felony delivery. This other question of, well, all these other elements of casual exchange, or all the other indicators of a casual exchange versus a felony delivery, the jury just never got to those issues. But upon this court's consideration, I think that this case is somewhat of an outlier, both in the very, very small amount of drugs.
Well, I've been waiting to hear your response to the acquittal first jury instructions being the remedy for the issue that you raised. Do you want to address that, or do you want me to probe you more on that? Because yes. I'm curious as to what your response is, because I think that's the state's remedy for this issue.
I think that I would propose that these issues should be kept separate. Certainly, they are connected in the sense that one leads to the other, but I think that this court can examine the entire issue as a matter of sufficiency rather than what is admittedly a plain error jury instruction issue. But to answer Your Honor's question,
because we've struggled with that quite a bit in the second-degree voluntary manslaughter context. So I was intrigued because this is the first time we're seeing it, or at least I've seen it, in the context of felony drug delivery and casual exchange.
I think that if the acquittal first, if my proposed solution was adopted, which is to sort of as a matter of common law interpret delivery to include these, I would argue it's not really putting additional elements into it, because the court is already having to examine that in making a distinction between felony delivery, whether a casual exchange instruction is supported at the trial court level, whether the evidence was sufficient to support a felony delivery conviction or a casual exchange conviction. I would argue that we're not actually inserting any additional elements into this, but what it would change is that at the trial court level, if as a matter of common law, this court said, these elements are part, when the legislature says, quote unquote, delivery for felony delivery, this would lead, that means X, Y, and Z. These affirmative, there must be some sort of preconceived plan, there must be these other indicators. What that would lead to would be a jury instruction rather than the inference that's currently set out in 3917-419, which is part of the confusion in this case. It would lead to a jury instruction on the front end as part of the elements of the felony delivery 3917-417, in which the jury would be instructed, or actually, I'm sorry, I guess where it would come is at the end when there's a definition section for the jury instructions. It would define that, and it would totally take out this issue of, well, if they don't ever get to casual exchange, have they properly examined the distinction between a casual exchange and a delivery.
And you're saying that should be done in every drug case?
I think that it would, I think logically, if this court adopted my argument, it would lead to probably a amendment to the pattern jury instructions, which would define, I mean, the same way that this court has ever defined a certain legislative word that should then be defined to the jury. I think that that's how that would play out. And so if the jury is just looking at this one page, count one, delivery of a controlled substance, they flip over to the instructions page, which would be taken from the pattern jury instructions, of course, and they say delivery means a transfer of a controlled substance with a preconceived intention, et cetera, et cetera, et cetera, and they make their full determination of whether the state met those elements without ever having to get to, well, let's read this legislative inference in 419, let's then look at the elements of casual exchange on the next page, and it sort of, I think it cures the order of consideration issue because everything is there under the count that is instructed for 417. And I've run over my time, but I suppose just to summarize, I think you could fix it either way, but it's kind of to address the order of consideration issue is kind of putting a Band-Aid on it, when my position is that simply further explaining what the word delivery means, that would be the actual fix.
Thank you, counsel.
Morning, General.
Good morning, Judge. May it please the court. Counsel, my name is Will Lundy, and I represent the state of Tennessee in this appeal. I want to start with the defendant's contention that this court can interpret the word deliver to include within itself this idea that the state must prove a predetermined plan or design in order to prove delivery of a controlled substance rather than casual exchange. And I would point the court to just the mens rea element of this offense, which is knowing. In other words, the state must prove that the defendant knowingly transferred a controlled substance to the victim, and that is to say that he was aware of just aware of the nature of his actions. He had to be aware that he was transferring or giving a controlled substance to the victim. That is what the state was required to prove in this case. And the defendant makes no argument that didn't happen. The defendant makes no argument that he didn't know that he was giving a controlled substance to the victim. And as far as the sufficiency of the evidence goes, that's what the state was required to prove. And I would argue that the evidence is sufficient to prove that. As far as looking at this definition of the word deliver, the state's position is that to define the word deliver so as to require the state to prove a predetermined design or plan would be to impermissibly increase the mens rea element of the offense from this knowing, which is to say just awareness of the nature of his conduct, to some sort of premeditation. And this court does not amend statutes. And this court lacks the power to amend statutes. That is the prerogative of the legislature. If the legislature wishes to clarify it, it's more than welcome to do so. I think as far as the logical nature of the defendant's argument. I see where the defendant is coming from. I don't hear me saying that what he's saying is crazy, because I do understand the logic of it. But I think where we go wrong is when we look at a case like Helton or we look at a case like Click, where the court is looking to determine the sufficiency of the evidence to prove casual exchange and comes at it and says, well, it has to be without design because that's what we've decided casual means. That doesn't imply that it is therefore necessary on the other side to require the state to prove an absence of such a plan or design in order to prove delivery of a controlled substance. The same argument would apply if we were looking at, again, second degree murder and voluntary manslaughter. So in second degree murder, the state has to prove a knowing killing. The defendant has to be aware that what he was doing would almost certainly, I think is the language, to kill the victim. But in order to prove voluntary manslaughter, the state has to prove a knowing killing, and the state also has to prove adequate provocation. And that's a separate element that, as far as my understanding of the law at this point, the state affirmatively must prove adequate provocation in order to prove voluntary manslaughter, despite the fact that voluntary manslaughter is a lesser included offense and has this one other thing to prove. And so here, the same thing is true. The state must only prove that the defendant knowingly delivered a controlled substance to the victim, and the evidence supports that here.
Isn't that kind of the defendant's point, though, that if the state makes that showing, they've proven a felony delivery, and under a sequential jury instruction, you would never have a casual exchange, because every casual exchange would also involve a knowing transfer?
That is certainly the defendant's argument, and as far as the jury instruction question, which I think is where your question is leading to, the Supreme Court has explained that the sort of top-down approach, we have to acquit of the greater offense before we move on to the lesser offenses, that's entirely constitutional.
Then how do we ever get to a voluntary manslaughter conviction? Because if you have a knowing killing, you would stop at second degree, wouldn't you?
They certainly can, and in certain cases, when the jury is instructed on voluntary manslaughter, this court has repeatedly held that is permissible, and that the jury considers it, or is at least it's able to do so. In State v. Black and many of the cases that it cites, this court has done exactly that.
But haven't the courts also advised that the jury should be instructed as to the difference between second-degree murder and voluntary manslaughter as part of the second-degree murder instruction?
I believe so, Your Honor. I'd have to look at the case law a little more clearly to see all of that.
And isn't that very similar to what the appellant is asking us to do here, is to just provide that distinction in the actual definition for delivery?
No, I don't think he's asking. I think he's asking for more than that. I think he's asking for.
But in a sense.
Yes. In a sense, yes, but he is asking for significantly more than that, and I think more than this court has the power to grant. But when it comes to the jury instructions in this case, as I pointed out in my brief, the jury was presented with this inference of casual exchange instruction several times. It was presented with it, the trial court read that instruction to the jury. That instruction actually comes 2 pages before the sequential consideration instruction comes. So that all of that was on the jury's mind. It's not as though, and in fact, trial counsel argued that in his closing argument, that this is simply casual exchange, and the jury simply rejected that argument. So even here, if there were an argument perhaps that the jury just never heard the casual exchange instruction, it never came up, and was somehow precluded from even knowing that it existed, we may have a different situation. But here, the jury was well aware of the casual exchange instruction, and it simply rejected the idea that this was a casual exchange, and that's within the jury's prerogative. And when you look at a case like Click, which is one of the cases the defendant cites, that's exactly what the jury did. was they just simply rejected this idea that that this was a casual exchange. And to go into it a little bit, the evidence does show that this is more than a casual exchange. This court has characterized casual exchanges as being the sort of spontaneous, spur-of-the-moment kind of exchange of drugs between friends, and here we just didn't have that kind of spontaneity. The jury was more than able to infer, even if we were to assume the defendant's argument is correct on the definition of delivery, even if we assume that, the jury was more than entitled to conclude that the defendant and the victim had a plan here. The victim contacted, by the defendant's admission, the victim contacted him earlier that day and asked him to bring her, I believe it was heroin and cocaine, and you can hear that in the in his interview, and later on in the interview he admits that he brought her the dope, and again, so that the jury is permitted to infer that as she requested, he did exactly what she asked him to do, which was come to this rehabilitation center. And I want to point to that as well. This isn't a frat house, this isn't a bar, this isn't a party, this is a rehabilitation center. There's simply no way for her to have access to these drugs unless somebody smuggles them in. And so the jury is permitted to conclude that there was a plan between the two. And even counsel's point that they were talking on the phone back and forth that day, the jury is permitted to infer that they spoke about him bringing her drugs, particularly in light of the defendant's admission that that's what happened that day. So even under the defendant's standard, the evidence is still sufficient to prove that that this was more than just casual exchange. But again, the state's position is that all the state had to prove is that the defendant knowingly was aware that he was transferring a controlled substance to the victim, and that the evidence fully supports that. Does the court have any other questions particularly about the jury instruction issue?
Wouldn't it be, just to follow up, you give all these, I'm a big believer in the jury system and the juries. You give them all these instructions, and then toward the end, I think what we're talking about is this: you get through with everything, and then you start down the list. If you find the defendant guilty of delivery of a controlled substance, you shall so indicate, and your deliberation shall cease. I can't remember exactly what it says, but if you wouldn't it be preferable maybe, and like Judge McMullen, I was intrigued by the argument of a similar argument to this voluntary manslaughter thing and the order of consideration, and you just want to be sure that the jury is considering and thinking about everything that they need to and should. And so when you get to that last part, and I don't know how it is in this particular record, but when you start at the delivery instruction, wouldn't it be preferable to say something about casual exchange, like, for example, if you find the defendant guilty of delivery, to find the defendant guilty of delivery, you must consider that it is not a casual exchange, and as previously instructed on page 5 of a 25-page instruction, something in there to make it more likely that they're not going to just stop at delivery and forget about the casual exchange aspect of it. I'm not even sure I've stated a question, but I would like to have the jury instructions maybe a little bit better than they are right now. Your
Honor, I think ultimately I'm trying to get to the nub of your question, and I think I understand where you're coming from. And when it comes to the jury instruction itself, of course, here we're on plain error. and the defendant is required to prove a violation of a clear and unequivocal rule of law. And in light of Black and in light of all of these other cases, we don't have that here, so this just isn't the case. And more than that, I think with regard to the just to the definition of deliver, and can we redefine deliver and make it a little clearer that what the state has to prove, or try and find that distinction between delivery and casual exchange. I think that's the prerogative of the legislature rather than this court. And I mean, there's, whether we like it or not, the statutes are written the way they're written, and and so that's what we're given. And the same thing's true with second-degree murder and voluntary manslaughter. It's the exact same argument. It's the exact same logic. And again, then this court has approved it.
We need to expand the definition of delivery. I agree, that's legislative job.
Yeah.
But when we have a statute that says this is a crime, and we say that we have something that says this is a lesser crime, casual exchange, and now jury, here's what you do. I mean, we need to tell them how to do it.
Yeah,
I mean,
and
that's the trial court, not us, the trial court. But we might be able to help out a little bit on a case, perhaps like this, where we can suggest, I don't know, a more clear way for the jury.
Yeah, I agree, Judge Wiedemeyer. That's exactly what we did before we had a clear jury instruction and the pattern jury instructions for second-degree murder and voluntary manslaughter. So I take Judge Wiedemeyer's point as well.
Yeah, and as far as just providing guidance to the lower courts, I would have to think very hard about the propriety of that, particularly in a case where we're talking about plain error.
But how else would it have come up?
The defendant certainly could have objected at trial, or objected to the jury instruction at the time, and just didn't do that. But I mean, if we were here and this had been preserved, maybe we would have a different question. And as far as the guidance question, and I'm honestly having this discussion, face to face, I'm not sure where I would come down on the question of when is it appropriate to give that kind of guidance. As long as it might be appropriate here to say we should do this. I think, for one thing, the trial court. I mean, again, the pattern instruction for casual exchange was given, and it was given, before the sequential order of consideration instruction as well. So, I mean, you have this delivery instruction and then you have this casual exchange instruction. So, I don't know how we would do that any better without altering the elements of the offenses in order to combine them into one instruction. But as far as the propriety of giving some guidance to the lower courts, as long as the court maintains, is aware that we're here on plain error, we can potentially affirm the way the court did it here and provide some guidance for the future.
This defendant may not be able to get over the plain error hurdle. I understand that.
Right.
But in our opinion, whether he does or doesn't get relief, we might be able to point out what we've been talking about here. I don't disagree with what you're saying or with what defense counsel
and if the court has an idea about how to do it better, I don't think the state would be opposed to to more clarity.
So just so I'm clear, the way this would have come up properly preserved would have been a request from defense trial counsel for a special jury instruction on casual exchange in conjunction with the delivery, or?
As far as I think, I'm not. I really don't know,
Okay.
Your Honor. I haven't considered how to, how pragmatically to make it better.
In the acquittal, because
Yeah.
clearly they didn't go down to any of the lessers.
Right.
So I guess I'm just trying to visualize
Yeah,
how that would have been presented.
Yeah,
to the
I think
trial
the
court
defendant
for
would certainly have had to have objected to the way that the jury instructions were written, and somehow brought that to the trial court's attention and litigated it with regard to how it would be preserved. But again, if the court court is dissatisfied with the way the trial court did it here, even though it's not plain error, which I don't believe it is, then I guess I would.
I don't think
You know better than I do how to craft those things, so I would leave it to you.
I don't think that we're saying that we're dissatisfied. We're just contemplating what would have been a better remedy below, given the argument that there is some, admittedly by the state, some overlap between the definition of knowing delivery and casual exchange here. So that's all that we're doing. And we were just having, obviously our discussion with you as we do in oral argument.
Yeah, and I wish I could be a little more helpful to you in having that discussion. With just the last remaining minute, the defendant did make one other argument in his brief, but that was an argument about the admissibility of the defendant's statement. That comes in under plain error as well. The defendant didn't raise that in his motion for a new trial. I brought out the plain error argument in my brief, and the defendant made no reply in his reply brief and has not argued it here. So I would just ask this court not to review that issue. If the court has any questions about it, I'm happy to answer them. But in light of where we are with 2 minutes left in my time, I would just ask the court to ignore it.
Very well taken. It has not been argued here. It was not responded to in your reply brief, and we understand the state's position.
Okay. Thank you, Your Honor. If the court has no further questions, the state would simply ask this court to affirm. Thank you.
All right, thank you, General. I think you're learning about your next case if you're at trial. What you might need to try to do there, Counselor.
Yes.
I assume you weren't representing him at trial. This is an appellate.
I would like to say that was true, Your Honor, but all my good ideas come after the fact in front of this court. But unfortunately, one thing I do want to point out is the difference between the pattern instruction we have for distinguishing between second-degree murder and voluntary manslaughter is that the pattern instruction is really quite clear. It says simply the distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation, et cetera, et cetera. And what we have here is that the only thing that the jury was instructed on was this legislative inference, and that legislative inference, that language was provided, but it was provided after the elements of casual exchange. And so we can't have it both ways, where on the one hand we think, okay, well, because it was argued in closing, because the jury heard the instructions from the court, because they read the instructions in full, they had it on their mind. Well, if the jury did in fact follow the instructions as they were given, then they considered the elements sequentially, and they never got to that legislative inference. They never had, sure, they heard it, but they heard a lot of things over the course of this 4 or 5 day trial. And so also, and I talked about this in my brief, when we're looking at these other cases where this court and the Supreme, I believe just this court, have affirmed the use of the manslaughter instruction and the sequential instructions, and most, although not all admittedly, in most of those cases that jury instruction is given after the elements of second-degree murder. And so the jury never gets to manslaughter if they don't, they are told what the difference is as they're considering the elements of second-degree murder. And so that's just not how this currently operates with this interplay between the delivery and the casual exchange.
So the state's hammering plain error here, that you don't get over plain error. What's your strongest argument?
I think, Your Honor, the strongest argument is that given the interplay between the order of consideration instruction and this requirement, which my position is that there is quite clear case law that this inference must be given if it's supported by the proof. Given the way that the jury was instructed, where this legislative inference, it is given, but as a practical matter, it's located in a place that the jury wouldn't consider it. That the instructions as given in this case don't give that their jury instructions were improper. They didn't give a full
How
and
does
fair.
it violate a clear and unequivocal rule of law?
And I believe that that is the clear and unequivocal rule of law that was violated, is that the jury must be given a full and fair charge of all the elements of the offense. Our case law is clear that this legislative inference must be instructed when supported by the proof. It was supported by the proof, and so the jury was not able to get there because it was given in the wrong place. Had it been instructed as part of the...
But there's no law that requires it be given right after or simultaneously with the felony drug offense.
I agree with that, Your Honor, but
The
I
highest
suppose...
offense.
I'm
Yeah,
sorry,
I'm
Your
sorry,
Honor.
I'm just talking out in my head. Go ahead.
But I suppose, Your Honor, that I would rest on the broader principle that, I mean, the reality is we don't have cases or statutes that specifically define every single lesser included situation, every single scenario that may come out based on the elements of these lesser included offenses. But we do have this broad principle that it must be properly presented to the jury in a way that they can consider it and apply it fairly to the facts of the case. And so by making what I would characterize as a mistake of putting it in the wrong place, it would be, perhaps this is a bad analogy, but if we had taken one of the elements of casual exchange and put them in a different section, say put it in the final consideration instructions, I believe that would be an improper charge of the law because the jury wouldn't know to consider that element as part of its deliberation on the casual exchange offense. And so by placing this inference, the only distinction the jury had between felony delivery and casual exchange, it's a flawed distinction, but by placing the only distinction in a place where we ensured the jury wouldn't get to it based on the order of consideration, that's how the trial court failed to fully and fairly give instruct the jury as to the elements of the offenses in this case. And so that's the best argument I have on that, Your Honor.
And you are not going to respond to any other?
The suppression issue, my position, it's been preserved for Mr. Atkins in the event that we have any intervening changes in the law in the future.
Thank you, counsel.
Thank you, Your Honors.
All right, thank you, both attorneys. Very good briefs written and good arguments today. And I don't want you, Counselor, I don't want you to think